Hi, my name is Konotomo. I've been a practicing California attorney for 6.5 years, and today we're going to be talking about 6-7. Specifically, the 6-7 lawsuit launched by Perdue Foods. Because I have the actual court documents and we're going to be taking a look at them today. So Perdue Foods is suing a competitor alleging that they've copied its viral 6-7 chicken nuggets. The lawsuit claims the similarities have caused customer confusion and cost Perdue shelf space at a major retailer, which I believe is Walmart. So they're suing Soul's Kitchen, who made this 6-7 chicken nuggets after they did. Now, of course, you'll know that neither Perdue Foods nor Soul's Kitchen began the viral 6-7 meme. They are simply latching onto it. You will also note that there is nothing revolutionary in creating breaded-shaped white chicken patties in the shape of 6-7. Because, you cannot copyright Arabic numerals. Not something you can do. Despite the fact that they have not created anything original, they have launched a lawsuit against Soul's Kitchen, which we have right here. So this is in the Eastern District of Virginia, and it's Perdue Foods, the plaintiff, v. John Soul's Foods, Inc., the defendant. So let's take a look at this lawsuit, go through some of the facts, and then we're going to take a look at the injunction that they have also filed for, which has not been ruled on yet, and whether I think this injunction is going to be approved or not. If they get this injunction through, it's most likely that John Soul's Foods is going to have to remove their 6-7 chicken nuggies from Walmart and other major retailers. So this is an action for false designation of origin, trademark, and trade dress infringement and unfair competition arriving from Soul's adoption of the 6-7 designation and a highly similar breaded numeral logo and packaging presentation for frozen chicken nuggies after Perdue launched and nationally promoted its 6-7 chicken nuggets. You've trademarked 6-7 chicken nuggets, Perdue? Is that what I'm hearing? That's insane. Soul's action violates the Lanham Act, 15 U.S.C. 1125, infringes Perdue's trademark rights. They have apparently trademarked 6-7 chicken nuggies, despite the fact that that's not something they came up with, and constitutes common law unfair competition. Chat, unfair competition is basically when a competitor creates themselves the qualities of having an unfair advantage in the marketplace. This can be done by, for example, having slave labor, not paying people that work for you proper wages so that you can undercut other companies with what you charge, or basically, and this is what I believe Perdue's allegations are here, they're taking the thoughts, the minds of Perdue, their smartness in creating our 6-7 chicken nuggets and selling them for themselves without having to do the hard work of coming up with 6-7 chicken nuggies, which is insane. Perdue is a Maryland limited liability company with its principal place of business in Maryland, and Soul's is a Texas corporation with its principal place of business in Texas. One has to ask then, if one of these companies is Maryland, the other one is Texas, why are they filed in Virginia? My guess would be that Perdue is judge shopping and trying to find either friendly law or a friendly judge who is most likely to find that their 6-7 chicken nuggies are incredibly original. They're not. So let's go into the actual factual allegations. In April 2026, Perdue launched a new product called 6-7 Chicken Nuggies. It's applied to register the 6-7 marks with the USPTO. I believe that's a US something in trademark office under serial numbers 997-96669, 997-96671, and you get it. And these are what they actually, trademarked. 6-7 with the little hands. You'll notice that this is just what everyone does when you do the 6-7. You bring your hands up and down. Can I need a 6-7 toggle? No, I don't. In addition to the Perdue 6-7 marks, Perdue has developed distinctive packaging trade dress for its chicken nuggies, which we saw earlier. See, these are the soles, and this is the Perdue. You know, this is clearly the same thing. Chat, they're not. They're not. They're really not. These are incredibly different. Also, these are limited edition. Why would you limit edition chicken nuggets? They're insane. Oh my God, I just noticed this. What does it mean? 6-7. So it is the cartoon hand supporting and carrying the numerals, which is part of the 6-7 meme that Perdue is copying. Playful hand-drawn stars, smiley faces, squiggles, and youth-oriented style on the related advertising, which, you know, they're stealing from. It's limited edition because it's a fad and they got to make their buck. True. This is silly and hurting my brain. It is silly and should hurt your brain. Perdue publicly announces 6-7 chicken nuggies on April 16, 2026, and immediately began nationally promoting the product. Perdue then started selling them as early as April 27, 2026, when Perdue fulfilled giveaway orders by shipping marked products across state line. By May 1st, Perdue's 6-7 nuggies were available in Walmarts nationwide. And they filed trademark applications for these 6-7 marks with the U.S. Patent and Trademark Office. Are you insane? It hasn't been said if they've actually been granted the trademark on these or not, just that they've applied for them. So this then goes through all the different ways that they've been marketing themselves. They've been including the 6-7 trademarks on their website. Right here as well. Since Perdue announced and launched the product, Perdue's 6-7 chicken nuggets have been referenced nationally in a segment on Late Night with Seth Meyers. I would imagine to make fun of them. BuzzFeed Tasty, Dexerto, Dexerto right here making fun of you. Making fun of you. Pure Wow and other media outlets. More than a month after Perdue launched and nationally promoted its 6-7 chicken nuggies, Souls announced and promoted a directly competing chicken nugget product using the same 6-7 designation and a highly similar breaded numeral design. Chat, they don't own the idea of making a number breaded. We've been breading things forever. Stars, dinosaurs, fire trucks. No. Soul's product is sold and promoted as 6-7 chicken nuggets. The dominant commercial impression of Soul's designation is the same as Perdue's 6-7 designation. So that's the crux of the lawsuit. They then do their own side-by-side comparison of the complaint just to do like a little visual for the judge. I've actually been encouraged at a previous law firm that I worked at to include pictures in my complaints because pictures are worth 1,000 words. And I actually do find pictures to be helpful when you're either like including a proper policy that, you know, if you're trying to. So what I do, for example, are these wage and hour lawsuits where I basically sue against a company for not paying their employees right, for having, you know, bad policies. So I'll sometimes just take the bad policy and put it in the complaint. Pictures would make sense. Yeah, exactly. So Souls used the challenge branding, which is the 6-7 designation, on his product packaging and in advertising, including here. Finally, 6-7 makes sense. Jesus Christ, man. Do we have to sell everything to children? Do we have to make 6-7 nuggies for them too? Souls has publicly announced that its 6-7 chicken nuggets will be sold in Kroger and Aldi stores nationwide beginning in July, which is why we're bringing this complaint now, so that we can get an injunction against them. Given the above facts, Souls' use of the challenge branding is likely to cause consumers and retail buyers to believe mistakenly that Souls products originates with and is affiliated with, sponsored, approved or authorized by Perdue. I believe it has Souls Kitchen in big letters right there. So I don't think anyone's going to think that they're buying the Perdue 6-7 chicken nuggies. But, you know, I do believe that you think you're buying some sort of 6-7 chicken nuggies. Didn't expect to find a VTuber lawyer, but I'm not objecting. Well, you can object with my objection emote. There you go. We love that here. Also, Dandelion Days VT, I really hope you enjoy your lurk. The argument section of the injunction is well structured. So in order to succeed on an injunction to get a court to act before the judgment in a lawsuit. Welcome in. Thank you for gifting a tier 1 sub. I just want a muscle mommy to Kumi is buttery gawk. Thank you for gifting a tier 1 sub to Kumi is buttery gawk. I think there'll be some cuts into YouTube. Keeping this all in. Let's keep all of this in right now. Who knows? Who the fuck knows? So again, when you are bringing a motion for an injunction, this is before the court has even heard anything on the merits of the action, okay? So this is before the defendant is given a chance to provide an answer. This is before the defendant is brought in to provide like a motion to dismiss the complaint or to believe that the complaint doesn't have legal viability. They just immediately file and ask the court to stop and take this other product off the shelves before it even happens. So that has 4 different facts to it. First, you have to be able to show that you're likely to succeed on the merits, that you are suffering, will continue to suffer irreparable harm. Irreparable harm means that this is harm that can't just be satisfied by money, okay? You have to be able to give that you have to be able to stop the harm that's happening to you, which is selling this other product because of something else that's happening that money can't fix. This would be, for example, product confusion. This would be, for example, the idea that customers are going to be permanently confused by this is going to diminish the status of your brand in the long term. The balance of the equities favor granting an injunction. Thank you, Anonymous Gifter, for gifting a tier 1 sub to Omegaverse Lover 69. Again, that name is Omegaverse Lover 69. Thank you. The balance of the equities means that the amount of damage Perdue is likely to face by these 6-7 chicken nuggies staying on the shelves is more damage than would happen if you stop this retailer from selling these chicken nuggies. And last is the public interest favors granting an injunction, which is always bullshit. Let's see what they write here. The final factor, the public interest also favors granting an injunction. Preventing consumers from being confused serves the public interest, according to tool checks. An injunction in this case would serve the public interest by preventing future consumers from being misled. So basically the idea is that the 4th factor for giving a preliminary injunction is the fact that, you know, we're going to prevent consumers from being confused, and that benefits consumers. Anonymous Gifter, thank you for gifting a tier 1 sub to Ride On Daddy. Again, thank you for gifting a tier 1 sub to Ride On Daddy. I love Ride On Daddy. Trademark infringement deceives consumers, and there's a public interest in making this misconduct unprofitable. A narrow injunction will help consumers and retail buyers distinguish Perdue's products from Sol's products, while leaving Sol's free to compete under a non-confusing designation and packaging presentation. Basically, stop them from making this product, prevent consumer confusion, and if they want to make chicken nuggies, they can. They just can't make our goddamn chicken nuggies that we're making first. We own 6-7 chicken nuggies. No, they don't. No, they don't. Like, Perdue makes dinosaur nuggies. Everyone makes dinosaur nuggies. Dinosaur nuggies aren't, causing customer confusion. Making 6-7 meme nuggets that you didn't even create, you didn't start the meme, does not create customer confusion. You're riding on another wave. That is corporate greed at its worst. So the last factor for a bond is the requirement for the last factor for an injunction is the requirement of a bond. So Rule 65C of the Rules of Civil Procedure require the court to address security an amount that the court considers proper. What do you mean? All dino luggage are licensed by real dinosaurs. As a consumer, I've always assumed that. That's true. Thank you, Doolib. I forgot that dino nuggies are licensed by real dinosaurs. It's official. I'm not drinking my coffee till after my stream. I'm dying from the names. Great. All right, we're good? We're good. Okay, Rule 65C of the Rules of Civil Procedure require that if you're going to basically ask the court to give an injunction to stop someone from doing something, you have to put an amount of money on the line that would be enough if presented and provided to the other side, to basically say that, if the preliminary injunction is found to be invalid, to have been wrongfully given, to basically compensate the other side for this. And they're arguing that because Perdue respectfully requested the court require no bond, because the requested injunction would merely require Solus to refrain from using the infringing branding to sell chicken nuggets. Hey, chat, here's a fun fact. Whenever an attorney uses the word merely, for example, this is merely an attempt to stop them from using this infringing branding, that means they don't have an argument. That means their only argument is to diminish the other side, or to diminish how weighty the actions that they're doing are. So if you see the word merely, know that there's no legal sufficiency to their argument. Like mere denial? Exactly, like mere denial. So we'll be checking in on this in a few weeks. We'll see if the preliminary injunction is granted. My guess is that it's probably going to be granted because the judge probably doesn't quite understand where the 6-7 meme comes from. They don't understand that this isn't something that's real and unique that's being made by Perdue, that they're instead just corporately glossing over an existing media and trying to take advantage of it. So my guess is that this injunction is probably going to be put into place, and that Perdue Foods, which is a major corporation, one of the biggest food processors in the United States, is going to be able to silence its competitors who are merely trying to compete with them. So, chat, that's what I wanted to talk about with this. And the declaration that supports the injunction, they include more pictures of the 6-7 chicken nuggies. They include this wonderful image from the Exerto, actually expressing I saw 6-7 nuggets at Walmart 3 weeks ago. Shameless Kitchen, they already made them. They've basically taken screenshots from like Instagram comments of people confusing the Soul's Kitchen nuggies with the nuggies that they saw in Walmart from Perdue. So they're using Facebook and Instagram and Twitter posts to demonstrate the fact that consumers are actually genuinely confused about which nuggies are which. They're genuinely using shit posts to satisfy the case, which is insane. So we'll check on this in a few weeks. Again, I think it's likely going to be granted, but who knows? Maybe this judge will not be an idiot. I mean, maybe this judge will be fair and balanced.